Today we're looking at the chapter Judiciary. This chapter is highly important for examination purposes and questions do come out on a yearly basis. The controversial areas would be in relation to the appointment of the judiciary. Since there has been a new system of appointment today, we have to consider the old system and the new system in a while more. And before we proceed to the controversial areas, I would like to cover several general issues first, namely the roles, responsibility, and functions of the judiciary. Secondly, the old system of appointment, and most importantly, the current system of appointment. Judiciary was explained by Professor A.B. Dicey, whereby he mentioned that the judiciary is the fountain of justice, and thereby any party with a grievance would inherently visit the court to seek for redress. In that sense, the role of judiciary is as the better protector of our civil liberty. This liberty is upheld in the court by applying case law and also acts of parliament. Besides the role of judiciary, we also need to consider what is the responsibility of the judiciary. The responsibility bared by the judiciary is a heavy one. They have to uphold two very important constitutional properties, which are the separation of powers and also parliamentary supremacy. And this is upheld when judges face an act of parliament. Think about it. If a judge were to apply a literal interpretation in relation to an enactment, he would be within his boundaries and therefore upholding separation of powers and also parliamentary supremacy. Unless he goes beyond his powers and starts to make law by re-enacting the words of parliament, he would then be entering into parliament's province, and this will go against two very important constitutional properties, which are separation of powers and parliamentary supremacy. Moving on from here, besides responsibility held by them, they do have several functions that they have to carry out, namely settling dispute, case management, training, extrajudicial activities, and also involving themselves in judicial review. In relation to dispute settlement, they would have to settle cases in two areas, namely civil and criminal cases. In this situation, firstly, they have to determine the procedure involved in the case. Having done this, they have to proceed to discuss what are the facts that has to be proven, and then only apply the settled law. Having done that, they would come to a decision, write the decision out, and finally decide on the issue of course. And this may take several days, weeks, and even several years. But of course, settling dispute is their primary role, according to Professor A.B. Dicey. Besides settling dispute, the second function here is case management. This is a new responsibility or function introduced after 99 reforms by Lord Woolf. Case management involves a situation where a judge would have to manage the court system. Prior to this, the entire management of the court system was in the hands of the lawyers, and of course, there was tremendous abuse of power during those days. However, after case management, the judge would need to adopt a new role, that is, the role of a manager. He would have to basically manage the entire litigation, including reading the newspaper, reading decisions, deciding on which witness may come to court, and so forth. This is a new role introduced by Lord Woolf after the reforms to the civil procedure rules. Subsequent to case management, judges would also need to involve themselves in training other judges to cope with changes. Obviously, training was a reluctant move for most judges, as they had to be trained first before they could train subsequent judges. But after accepting training for themselves, senior judges today would train junior judges on how to basically manage cases. So this would be the third function that they would have to practice in the court itself. Besides training, senior judges would have to involve themselves in extrajudicial activities, including providing lectures and sermons, writing journals for various reporting companies, and also giving evidence or heading government inquiry. But these are limited only to senior judges who have served a long time in the court process. And the final function of judiciary would be judicial review. In terms of the judicial review, this has been created by the judiciary for the last 40 years, and this would be a situation where they would have to look into the exercise of powers by the executive. It is a separate division from dispute settlement. We'll come back to this area in a short while.